another 102 days.
Thank you. Honorable Sri Mahesh Jethmalani.
Honorable Chairman, sir, I thank you profusely for permitting me to speak in support of the Criminal Procedure Identification Bill 2022, passed by the Lok Sabha and laid before this Honorable House by the Honorable Minister. Honorable Chairman, I'll first deal with the arguments raised by Mr. Chidambaram, Honorable Member in the opposition. Given his weight, his experience, about the fact that he's been presiding himself or has presided himself over the passing of many statutes. Now, the first argument which he raised was that why after 102 years? Well, I am not one of the people who I'm not associated with the drafting of this bill, but I can only presume the reason why this bill has been passed now. This bill has been passed because the present government, in the light of its experience of the last 7-8 years, has realized that previous governments, including those which Mr. Chidambaram was a part of, have relied only upon the Identification of Prisoners Act, which is an outdated, obsolete act, because the technological use of that act it no longer holds good except for some provisions. And my lord, advanced technological improvements, particularly the use of biometrics, my lord, which is now the gold standard for investigation of crime and for detection of criminals, is now worldwide used, including USA. And I will point out that some of the facts which he has stated are quite wrong. So, my lord, what I'm saying, I beg your pardon. Force of habit, sir. Mr. Chairman, the first argument is that it is never too late to rectify a delay, particularly when that delay has been found to prolong detection and trials. And, my lord, most important, the conviction rates in this country have suffered as a result of not bringing in the technological advancements in biometrics which help to detect that crime. Honorable Chairman, I'll deal with the constitutional challenges which Mr. Chidambaram has raised later on. But let me deal with his challenge to the definition. He says that the Supreme Court has barred as unconstitutional in Selvi's case, a case of 2010 or 11, the use of narco-analysis, brain mapping, and lie detector tests. The language of this act, this bill, which has been introduced, in no way permits the use of those techniques which Mr. Chidambaram says has been, with Selvi's case says, have been barred as unconstitutional. Mr. Chairman, I would request Mr. Chidambaram and other members of the House to kindly take a look again at the definition which he referred to. Measurements. He cavilled against the definition of measurements. Measurements includes finger impressions, palm print impressions, footprint impressions, photographs, iris and retina scan. I'll come to how important the development in iris and retina scan have been in other jurisdictions and how they've helped in the detection of crime. But he seems to have an objection and says that the world's physical and biological samples and their analysis allow the government to smuggle in indirectly what is prohibited by law, i.e. the results of narco-analysis, brain mapping, and lie detector tests. Now, sir, a simple look at the language, and if Mr. Chidambaram would have read it more closely, he would have realized that all these three methods of obtaining evidence are by inducing an accused person or a convict, you have to induce them with external stimuli. Thus, in the case of lie detector test, you have to put a lie detector. You have to attach an external device to get stimuli. This is neither a physical or a biological attribute of any individual. In the case of brain mapping, electrodes are put to a brain. An external stimuli again to get brain waves and map the responses of an accused person or a convict. And then the third, which is narco-analysis, you use a drug, a truth serum, to extract the truth from a person accused of an offense. The definition of physical of measurements, i.e., physical and biological attributes, do not and cannot take within its sweep these kind of tests. These are not attributes of a person, neither physical or behavioral, but these are tests conducted and responses given, either oral, in the case of truth serum drugs, or behavior, sensory, in the case of others, like, for instance, brain mapping. So you give a sensory response. Neither of these come within the definition of physical or behavioral attributes. Then my friend, Mr. Chidambaram, and not here I agree with him, I must say I am in agreement with him, has a problem with Section 3. And many people have had this problem. It has been voiced in the other house as well. He says that certain classes, apart from convicted criminals and people arrested and facing trial, he says, the other classes, which are those who are to give security, and they are mainly for petty offenses, and detainees. And what I'm particularly concerned about detainees, because we know the rigors of the emergency. We know what Mr. Chidambaram's government did in 1975 when they detained thousands of opposition leaders for petty offenses, purely on political grounds. So I'm in agreement on that issue. Perhaps that part needs a second look at. Convicts and under trials must be subjected to the provisions of this Act. But there is a case made, and I agree with Mr. Chidambaram, as I said, that yes, people under 110 of the Criminal Procedure Code, that is for giving security for good behavior, and the other class of persons, detainees mainly, who can be subjected to political vendor, and experience shows, particularly in 1975, more than 20,000 people were subjected to that kind of treatment, should be prohibited from the rigors of this Act. Then, sir, he says, Section 4, and he says that on law enforcement. Now, as far as law enforcement is concerned, this is only sharing evidence. This is only the sharing of evidence. Other investigating agencies involved in law enforcement, they only get to analyze that data. So the origins of this entire record basis came in England in 1920. In 1920, this Act was passed. Now, one of the criticisms I've heard in the other house, when I've heard their speeches, is that this is a colonial legislation. You are perpetuating a colonial legacy and, in fact, making provisions which are even more stringent. The fact of the matter is, A, it is not a colonial legacy. In England itself, in 1901, police first started using the kind of measures which the 1920 Act contemplates, which is fingerprints. At that time, those were the only biometrics. Fingerprints, footprints, and photographs. So those were the only measures used, and they were not colonial because they applied as much to UK citizens as it did to all colonies. What is colonial is the attitude in not updating those biometrics by present legislation. And that is what his government has been guilty of all these years. The Congress government, the UPA government for all these years, has not upgraded those biometrics to include the latest cutting-edge technology in biometrics, which I will come to at present. So the present bill seeks to replace and repeal the Identification of Prisoners Act. As I said, that had a limited scope, and in those days, the only measurements were photographs, footprints, and fingerprints. And today, we have much more. In the old days, there was a manual system of filing. So you had photographs of convicts and their fingerprints attached with it. There was a manual system. What this act seeks to do is to replace that outdated manual system with an updated digitalized system. In the old days, it used to be called a rogues gallery because only pictures were there. What my learned friend is asking for is a restriction of that rogues gallery on the basis of those biometrics only in use in 1920 and don't do it. Biometrics have always been in use. You always had to give your fingerprints and your footprints. But the new methods of identifying accused people, criminals, murderers, rapists, and the new methods have all been successful in detecting them. Those methods, for some reason, he finds intrusive. Now, one of his constitutional challenges I have already dealt with. I'll come to a second one now. The second constitutional challenge, the first one I take it is based on Selvi's, which is the right against self-incrimination, Article 23, which is on testimonial compulsion, is the right of privacy. Now, so the right of privacy is like an unruly horse. If you don't control it, it gallops away. The right of privacy is available to all honest citizens, to people who are not propelled towards crime or have committed crime. Mr. Chidambaram says that the right of privacy should also inure for murderers, rapists, fraudsters, forgers, and terrorists. Why? All that is being done is that a record is being kept of your misdeeds. And there are limitations. It only applies to two categories of persons: convicted criminals and to under trials.
Please.
It applies to under trials as well. Now, as far as under trials are concerned, there's a clear prescription in the proviso to Section 4. The proviso says that if you are acquitted, if somebody who's arrested but is subsequently arrested or discharged or not sent up for trial, any of these three categories, then the records which were obtained at the time of his arrest will cease. They'll be deleted. They'll be erased from the record. So there is adequate provision for that. Then there is a second. As regards under trial for offenses with more than 7 years, so anybody arrested for an offense of more than 7 years, he has the right to protest. In his case, it is only with his consent. For an offense with less than 7 years, the period. So if he is arrested for an offense with less than 7 years, only a compulsory subjection to an examination is ruled out. He has a right to protest and say, my offense is only less than 7 years. I do not want to give this. It is only in the case of arrestees who have been arrested for offenses, serious offenses, punishable with more than 7 years, does the Act come into operation. Now, so the second constitutional challenge which Mr. Chidambaram pointed out was a violation against privacy. Now, the judgment he referred to is Puttaswamy. If he had read Puttaswamy's judgment properly, he would have realized that that judgment of 9 judges is replete with references that in the case of detection of crime, the right of privacy stands excluded. It has referred to the European Convention, which says that detection of crime is an exception to the right of privacy. But he seems not to have read that part. Now, sir, what are some of these techniques which have been developed? Let me give you an example as to how useful these are and what is sought to be excluded on the grounds of privacy and other. Now, these are very important issues, but they are both misconceived, misplaced, and the Act does not violate those provisions of the Constitution. So as far as the progress in, one of the progresses that have been made, one of the advances that have been made in biometric development has been iris and retina scans, specifically referred to in the measurement section. Now please see why the iris scans are better than fingerprints. So nobody says any scan, no biometric can be 100% foolproof. We have used handwriting evidence. We have used signature evidence. We have used other types of evidence, including obtaining of nails, skin, etc. But many cases, that evidence has not stood up. But that doesn't mean that there are not good cases where that evidence will stand up. Many convictions have taken place on the basis of flawed biometrics, and convictions have taken place. Now, sir, see why iris scans. Iris scans are better than fingerprints for identification purposes. A, because they are more detailed and accurate. B, they are more sanitary. C, unlike fingerprints, they do not change from wear and tear. And finally, they are fast to scan and quick to retrieve. Now, sir, when someone's iris is scanned, what happens is a binary code of the image is created. It is this code of about 500 bits of data that is stored in a database. When that person later goes before an iris recognition scanner, the iris scan is measured against the code in the database and identity is authenticated. Now, sir, how fast is this technology evolving? A Carnegie Mellon engineering professor, which is already adopted in the United States, in some states, has recently developed the first long-range iris scanner which can identify if a murderer or a thief runs away in a getaway car from the scene of the offense. A police car chasing him can find out if the driver, if the criminal running away looks at his rear view mirror. The driver behind him of a police car chasing him can, from that very glance in a rear view mirror, find out the identity of the person. Wow. It is that advanced. And members of the opposition would not have that as part of a biometric testing data. And so the retinal scan is even more efficient. It assures the highest level of security, and out of all the biometric measures, the retinal scan is the most reliable biometric authentication system. Retinal scanning is actually used at high-risk centers like airport bases and border patrols. All this we should be using because it will help in detection of crime. Now, sir, since I'm from Maharashtra, I am particularly bemused by the fact that members of parliament from Maharashtra should be opposing this bill. On the 31st of March, I read an article, and I was highly proud. I was highly proud because it said Maharashtra to be the first state to launch criminals' biometric database. This is what it said. A digital fingerprint and iris scanning system to aid police investigations with a database of 6 lakh people with crime records will be launched by Maharashtra CM Uddhav Thackeray on Saturday. That was supposed to be on the 2nd of April. It was Gudi Padwa Day, New Year. Yes, it is on the 31st of March.
Please. Please.
Called automated metronomical biometrical identification system, AMBIS. It is a different kind of data digitalization. We have specific data on estimated 6.5 lakh on under trials and convicts. The entire information has been validated by the Bureau of Fingerprints experts. It will help law enforcing agencies track criminals, and that too at lightning speed. How is a government, an Agadi government in Maharashtra, which is about to introduce this database, opposing a bill which has a similar provision for a record, for a database?
Mr. नहीं, Mr. Jethmalani.
No, sir, but I'm told by honourable friend, Mr. Chidambaram is also elected for Maharashtra.
Mr. Jethmalani, please. Mr. Mahesh, Jethmalani, please. आप पीछे से yes, I know, I've heard. Please, Mr. Mahesh Jethmalani, please. There is a point of order, please. 1 minute. हाँ.
I don't like to disturb the member because it breaks the flow, but it is known. So 238 is my point of order, and it is on 238, page 84, part 5, reflect upon the conduct of persons in high authority. Chief Minister of Maharashtra is high authority. Wait, let me finish.
Please.
Let me finish.
Please.
Sir.
Please.
Sir, this is the problem.
Please, आप सब. Please.
Sir, I would like to ask the honourable...
Please.
Sir,
Please.
it is not whether good, bad, indifferent. I am only sticking to the rules. I don't want to disturb the members.
Right, Mr. Derek.
Simple.
We'll examine. Yes.
If you have a discussion, if you mention, it has to be based on a substantive motion drawn in proper terms.
Please,
I'm afraid
we'll
this
examine.
is not drawn
Please.
on proper terms.
Please.
Substantive
Please.
motion.
Thank you.
Why should I want to disturb
Thank you.
if you're playing?
Sir, I'm referring to a newspaper report which hasn't been denied, and in fact, in my opinion, contrary to that of the learned member from West Bengal, the conduct of the chief...
Please.
The conduct
Please.
of...
Please.
The conduct of the Chief Minister of Maharashtra deserves commendation.
Yes.
I am actually praising him for having the same kind of record in Maharashtra. My learned friend doesn't understand that this is an act of praise on my part, not an act of condemnation. I am saying he should have followed it through. But of course,
Please.
if you want to defend a rogues gallery, like some members on that side want to do,
eloquently arguing, counter-arguing our this statement. But I want to ask him, and here, always in this house,
Please.
always in this house, we have followed that no papers should be referred. Means whatever statement comes in the paper,
Yes.
that
We'll
cannot
see.
be taken into
We'll see,
this house. And
We'll see it. We'll see. Yes, we'll see.
sir,
Please.
my flow will
Please.
not get disturbed by these kind of interruptions.
Please.
All I will say, sir, is that, I repeat, the gentleman who I referred to needs condemnation. He was supposed to launch this on the 2nd on Gudi Padwa Day. I'm a little surprised. Perhaps it was a case of political opportunism that because we introduced this bill, that launch was stopped. We stole the thunder which he was expecting to deliver, but I don't know. So, also, sir, I wonder whether those opposed to this bill are aware of one more project, and they should be made aware. Because it's all very well to talk on high constitutional provisions. After all, you're a learned lawyer, you're a constitutional expert, you're a one-time minister, but you can't run away from facts. So people are impressed by that kind of a persona. But, sir, behind it, there are no facts. Now, sir, there is something called the Crime and Criminal Network Tracking System. And incidentally, there may well be a conflict of interest on Mr. Chidambaram's part to raise this issue in this House, because he stands accused of a crime. I wonder whether those opposed to this bill are aware of CCTNS, Crime and Criminal Network Tracking System, a mission mode project under the National E-Governance Plan of the Government of India. Now, sir, under the aegis of the National Crime Bureau, the same bureau which is going to record data in this case, the same bureau, the National Crime Bureau, 36 states and union territories, as of 25th August 2020, are sharing a pan-India database consisting of precisely the type of records contemplated by this Act. So that there seems to be doublespeak on the part of members of the opposition. There is no unconstitutionality, there is no illegality. It is true that there's a case of disproportionality in the case of the types of persons covered by the Act. There is no point keeping arrestees and serious criminal convicts in the same category as detainees. There I agree and I empathize. And perhaps that is my only criticism of the Act, which I would kindly request the Honorable Home Minister to look into. We don't need to categorize these kinds of people with convicts and under trials. Under trials, acquitted in any case, have a right to have their records established and not to be forgotten. But, sir, as far as criminals are concerned, this is a very, very important Act because, sir, crime never dies, A. They have a right to be forgotten. Criminals have a right to be forgotten, but that right will only take place after they die posthumously. Then their records may be erased. Records in this country, by the way, sir, I may just say one more thing. Records in this country can be maintained for 75 years. One honorable member of the Lok Sabha said that in England, in India, the average age life expectancy is 69. Why have it for 75 years? So I may say that in England, records are preserved for 100 years from the date of birth of the criminal, for 100 years, for much more. And the life expectancy there is 80 years. So there is nothing wrong in having this. So as I said, sir, criminals have a right to their records being erased posthumously, unless, sir, they happen to be unfortunate enough to have their case the subject matter of a law report, in which case their misdeeds will remain forever. Sir, I wholeheartedly support the bill and all its provisions barring one.
Thank you. Mahesh Shri Sukhendu Shekhar Roy.